Dear colleagues, let us begin our panel. All speakers, almost all speakers, are assembled. Our today's panel is called Russian Industrial Policy in WTO Context. 2 hours ago, another panel ended, which was partly concerned with WTO accession and our opportunities that we now have thanks to the 18-year-long process that was over almost 2 years ago. We concentrated on the Eurasian Economic Union and the Customs Union. However, we couldn't neglect the issues of WTO. All speakers in this or that way touched upon that subject. It's been almost 2 years since our accession to the WTO, but even after these 2 years, the discussion in the public sphere is still raging, and the WTO is considered by many to be a beast that could actually drive our economy into a corner and limit our opportunity for maneuver. But this is not so, in my opinion, and this structure of WTO doesn't impede the development of national policy, which is now being actively discussed in Russia. And I think that the crowning of these discussions will be the law on industrial policy, which everyone is eagerly expecting. The agreement that was recently signed by Russia, Belarus, and Kazakhstan, the joint industrial policy on these states has been coordinated, and this Eurasian Union has to be one of the poles of modern war, and on the other hand, to be a kind of a very efficient link between Europe and the dynamically developing Asia-Pacific region. This link is now being formed through the possibility of future agreements on free trade zones. We're now in active talks with Vietnam, we're in talks with India, and we think that these processes will be finalized successfully in the near future. However, to be a serious focal point and to be an alternative of certain Euro-Atlantic countries, our Eurasian Union has to be pursuing very ambitious goals, which had been set as long ago as 1994 by Nazarbayev, who was one of the first who was speaking about the necessity of this process. Some of the milestones and the goals is the faster development of member states, their improved investment appeal, and removing any barriers in the industrial sphere. The integration processes that are now happening required extensive changes and modifications to the legislation of our countries, and effective integration between the three countries depends to a large extent on the development of legislative foundation, which was modified, among other things, thanks to the accession of Russia to the WTO. So we are now in a multilateral trade system. Having acceded to the WTO, Russia has received a legitimate and free access to a new jurisdiction. And we're sure that such international legal protection will help the promotion of Russian goods on international markets. The opportunities that the WTO offers to Russia will be discussed at this panel by our esteemed speakers. I think that a fly will be found in this ointment. We will be speaking about certain risks that our country and our economy is facing. And we'll also talk today about the possibilities of protection domestic manufacturers, which we are now actively using. We'll be talking about the purchase mechanisms, which are a measure of non-tariff protection. Another unit will be devoted to a very important aspect, which is the protection of intellectual property. And the role of such protection is all the more higher because the import of counterfeit production and illegal products and counterfeit products of consumer goods now makes us take very active steps. In a consumer industry, 2.8 trillion rubles is the turnover for the last year, and the experts consider that 30% or more of that are goods of dubious provenance, which damages our market a lot. It's not just counterfeit products, but also the products that are produced circumventing customs and industrial standards. I would like to start our discussion with giving the floor to Nikolai Mizulin, who is a partner of the company Meyer Brown. Nikolai is experienced in participation in a number of major litigations and disputes within the WTO. He has represented different countries, and he will be speaking about subsidies within the WTO and the experience of WTO in subsidizing car manufacturing, shipbuilding, plane building, the areas which are very important for our country and for our economy. Please. Thank you very much. Dear colleagues, my talk will be devoted to subsidizing within the WTO, and I am in complete agreement with the thesis put forward by our moderator. The risks pursuant to the accession of Russia to the WTO are being talked about, but if we look at the subject in more detail, we'll see that these risks are overblown. To begin, I'd like to say that everyone's doing that. Everyone's subsidizing their national manufacture. The forms and guises of state support and government support are various in various WTO countries, but it didn't change much since the creation of WTO. From the economic point of view, directed government support in various areas of economy when the expenses are controlled, this is quite justified. This is all countries of the WTO are in complete agreement about that. A simple example, Chile, which yesterday won over Spain, the world champion. About 40 years ago, the country was completely dependent on the export of copper, and that led to political changes. The subsidies that were used during the last 30 years made Chile from an export-oriented country to a quite diversified economy, and some of the industrial projects that were promoted was winemaking, fruit, agriculture, and something that was considered amazing back then, um, fish husbandry. And Chile is now one of the major world exporters of salmon after Norway. Plane building, the well-known Airbus, a well-known example of that. There was no plane building in Europe some decades ago, but now Airbus is one of the largest players on the global market. European agriculture, which is essentially it works at a loss, but in fact, in matter of fact, it's quite successful. So I would like to stress that subsidizing and active promotion of one's national policy is not a bad thing, and all WTO countries subsidize their manufacture, their industry in this or that way. I will focus on subsidizing industrial manufacturing. I won't speak about agricultural subsidizing because agriculture is a specific area, and there is a separate WTO agreement which is rather sloppy from the legal point of view, to tell the truth. So we'll look at a more relevant topic, which is more relevant for Russia as well. First, what is a subsidy? Three elements have to be ascertained. This is financial support with a certain role of the state, of the government. This support must provide a certain benefit to the subsidized entity as compared to market conditions, and it should be specific to if this is a non-specific subsidy, it's not a subsidy at all. I'll touch upon a few issues that are also relevant for Russia. Financial support is directly and explicitly stated in WTO rules. It can be direct cash subventions to certain subjects of economic activity, providing certain goods or services or infrastructure. A widespread form of subsidizing is giving loans by state financial institutions and providing state-sponsored guarantees. When the state directly subsidizes an entity, it's clear, but it's more complex, and it's more complex for dispute resolution when such financial support is given to state-run enterprises, or for example, if Gazprom is providing certain support to gas producers. Gazprom is controlled by the state, and it's largely state-owned. Is it a subsidy? It's not quite clear. The answer depends on the goals pursued by offering such subsidies to gas industry enterprises. Also a gray area are the issues of financing by supranational structures. For example, subsidies by the Eurasian Union bodies for the time being, it's not quite clear as well. Another complex situation is when financing is provided by private banks, which act on orders or instructions from state bodies. For example, if there is a debt, is it a financial action by the state? Again, it's not quite clear. If we do have the fact of financial support by the state ascertained, another element is the benefit, the advantage given by this action to a certain economic entity, as compared to the conditions they could have found on the free market. Depends on what you compare it to. It's basically a point of fact, a point of definition in which sector of economy this is happening. A serious problem arises when inside a state, for example Russia, in a certain sector there is no actively functioning private sector. For example, in gas sphere, it's very difficult to decide whether there is any advantage, because the current price for gas is managed by Gazprom, and private companies only have limited access to the gas transportation system. If the advantage is ascertained as well, another key issue also for the Russian economy and the Russian participation in the WTO is the specificity of the subsidies, which means that if anyone can receive this subsidy, the WTO doesn't regulate that and doesn't prohibit it. This is an important issue because at a certain point the requirement of subsidies to be specific was put forward by the United States when the US authorities that were responsible for trade protections were taking measures against Mexican production, and the main problem was double price formation, which is also a problem for Russia. Russia is being accused of that by its trade partners. So if the whole export out of Mexico was subject to such subsidies, in that case a subsidy is not specific, so no compensation measures can be taken against it on the WTO level. Why is that important? Again, the gas topic, which is one of the drivers of the Russian production and further development, many discussions were happening during the accession process, but it's very hard to provide any specific claims, because these are very non-specific issues regarding that it's largely monopolized. Let me repeat it. Three points are necessary: specificity, advantage, and state subvention. If a measure corresponds to these three criteria, we have to ask ourselves, how is this WTO subsidy regulated? WTO does not prohibit subsidies. It's a well-acknowledged element of trade policy of WTO countries. So just three cases when subsidies are prohibited. From the point of view of structure, the subsidies is forbidden when it's connected to the export. From the point of view of structure, import replacement subsidies are also banned. We know that quite well due to the programs of assembly of cars, when the spare parts are imported without paying customs duty. Up to 2018, we're exempt from that, but this is a good example of import replacement subsidy. These are two exceptions to the general rule of subsidies being okay. Subsidies are also forbidden in situations that are not connected to the structure, but rather to the effect. If we have a subsidy without these criminal or prohibited elements, and the effect of that subsidy is the negative influence on WTO countries and their economic interests, it also becomes forbidden. As you see, here we see an element of economic effect from certain state support measures, and disputing such subsidies becomes much more difficult, because you have not just to prove that it's a specific subsidy, but also that it has a certain negative influence on importing certain goods from WTO countries to Russia, or on the third markets, or dumping, or price pressure on global or national markets. Most subsidies in Russia fall under the third category. From the point of view of structure, there is nothing bad happening. Excuse me. I'll just pass on to certain elements that I was going to speak about, and those subsidies that occur in Russia are disputable from the point of view of effect. This is the problem of the evidence base. It would be very hard and time-consuming for those countries that would like to bring cases against us. It will take a long time to be manifested. So from the practical point of view, we can't really wait for successful claims regarding these forms of state support.
So as far as other countries are concerned, I'm not going into detail, but still, we have had a number of disputes within WTO, and a very exemplary case of how we should provide state support and to make it efficient is the WTO decision on the Airbus case. The dispute was submitted to WTO because there were contradictions between the EU and the United States. On the other hand, Brazil, the Russian Federation, and others know about the charges brought, and they are just ABCs for our countries. We know how to provide state support and how to evade the responsibility for this. In conclusion, I'd like to emphasize that in terms of trade policy of the Russian Federation, we have been inconsistent in terms of import duties. Historically, they were either brought down or increased, and Western countries insisted that they were close to zero. And going back to the 19th century, when we lost the Crimean War, one of the conditions was liberal trade policy and trade duties in particular. The trade policy of the Russian Empire on the whole was always consistent. When manufacturing enterprises were established in the 17th and 18th centuries, a very efficient and diverse system was created, including financial subsidies and manufacturing products at lower prices than market prices. And a very interesting form of the 18th century was state procurement. And I think this is the point where I could stop. And I think that other speakers will discuss it in more detail. So 3 questions to each speaker. Well, I welcome. Any questions? No. No questions. So the presentation was comprehensive, and now historical trends have been reversed a little bit, and we are no longer losing the trend, so we can protect our markets. The next speaker is Deputy Head of the Internal Market Protection, Natalia Minashkina, and she will speak on support of industries within Eurasian Economic Union and the methods of protection, including new possibilities within the new Eurasian Union that was recently created. Good afternoon, ladies and gentlemen. I'd like to thank you for the invitation and for the opportunity to speak here and to tell you about our work within the Customs Union. The state and its government have a lot of diverse tools to support its manufacturers, including external trade measures and internal domestic measures like subsidies, financial support, etc. As to external or foreign trade measures, they are applied within legal WTO space as well as customs union space, so we have to use the unified rules, and the margin of appreciation is much narrower now than it used to be. And thus, popularity, so to say, is growing for such instruments which are economic in nature and are designed to protect the manufacturers, like anti-dumping and compensation measures. They allow us to be very specific in relation to certain countries. And also the measures can be very sensitive financially to exporters and experts and can bring to an end imports at all. So, as far as the customs union is concerned, the most important thing is that starting with 1st July 2010, we have been using unified safeguard measures. So the introduction of such measures is decided upon at the supranational level. They have direct application and no other national regulations are required. These measures do not use the notions of Russian manufacturer or Russian economy. The terms customs union manufacturers or unified territory of the customs union are used. The major basic document regulating the application of the measures is the agreement of 2008, which prescribes all the regulations and also additional treaties, international treaties covering Belarus, Russia and Kazakhstan, including certain decisions of the second level, which allow to regulate certain outstanding issues. As to the legal framework, in 2011-12, the three countries, Russia, Belarus and Kazakhstan, signed a treaty on the functioning of multilateral trade system. And WTO norms and rules have become part of customs union documents, and the use of these measures are guided by the WTO standards. So, a few words on the competence transmission. At the moment, competence is focused in the Eurasian Economic Commission. It did not happen overnight. While the agreement and powers on introducing certain measures emerged in June 2010, the issue of investigation and other proceedings was outstanding because under the agreement, investigation should have been carried by the Customs Union Commission consisting of 3 vice premiers. Thus, they couldn't actually implement all this, so there was a transition period with this in view, and it lasted for 3 years, so that the national bodies like the Ministry of Trade and Industry in Russia, the Ministry of Foreign Affairs of Belarus, and the Ministry of Economy and Budget Planning in Kazakhstan were involved in all this. Last year, in June, the entire competence, including investigations, was transferred over to the Eurasian Economic Commission. So, we set up a special unit within the Commission, the Department of Market Protection, which considers all applications, is involved in the proceedings, investigative activities, and preparing proposals. The decision-making is at the level of the Collegium of the Eurasian Economic Commission. The national competence involves implementation of decisions and their implementation on the borders by customs bodies. So you see the anti-dumping measures on this slide. So 8 of them, and altogether there are 13 plus 5 special safeguard measures, including steel industry, consumer goods, automobiles, agricultural machinery, and so on. When the agreement came into effect in 2011, we started investigations, and so far we have had 10 completed investigations and 7 investigations introduced special measures. 4 investigations are still underway. Also, we reconsider a number of decisions. One of them relates to changing the measures and extending the term of their use. So, the second part of my presentation will deal with the novelties in the agreement, because, as you know, 3 countries signed the Treaty on creating a Eurasian Economic Union, which was discussed in the first half today, and the basic agreement was codified and included in the treaty. two articles were introduced to the treaty and Appendix number 8. The provisions of the agreement have been retained with a number of changes or amendments which could be split into two groups. And we'll start with the first one, that is technical changes, and a number of amendments which brings it in full conformity with WTO provisions. And on the slide, you can see the novelties, which are very important. So now we have, as of January 1st, new safeguard measures. Now they exist in the form of duties or quotas, or the amount of import which could not be exceeded. Now we have a new quota which is similar to currency quota, which is quite liberal and perhaps more acceptable. We also envisage additional measures to reconsider special safeguard measures. It used to be limited, and we could only extend the time limit. And according to WTO, a second investigation could be held. Now we have additional cases which are prescribed in order to make the response mechanism more flexible. Also, we specified a number of measures relating to transparency of the decisions and bringing information home to those stakeholders involved. So we also specify all notifications to be made and the deadlines for them concerning the decisions made, as well as the procedures of submitting them to stakeholders. Two major changes are as follows. First, proposals for the business community supported by the Ministry of Trade and Industry. They had to persuade us to do so, to convince other stakeholders of the Union, and we came to agreement as a result of this, and it is included in the first part of the treaty. We somewhat decreased the duration of proceedings, of a number of proceedings, and also included the norms which set the deadline for introducing preliminary safeguard measures. It used to be different because we had deadlines for submitting proposals, but the commissions had a full discretion to act as far as timeline is concerned. Now it's 6 months, and proposals to introduce preliminary anti-dumping measures may require the deadline of 6 months. 7 months, I'm sorry. And what is more important is that the treaty and the agreement are supplemented by the proposals to apply anti-dumping measures. And it was done in order to evade such cases which we used to have when investigations started and the importers and exporters, in order to prevent the introduction of certain measures, they started supplying goods to their storage, to their storage houses, and thus they actually brought to nil the effects of the measures, because the damage could be even greater than the measures proper. So in such cases, if they happen, the Commission, based on the results of the investigations, can apply the measure for the period of no more than 90 days after the preliminary measures were introduced, which is a kind of prevention, because we would like to avoid such situations, because the stakeholders should know that in case of bad faith measures, they will have to be sanctioned or they'll have to pay for them. Thank you, Natalia. Are there any questions? You mentioned in your excellent presentation a number of anti-dumping measures that were introduced, and in late May, EU sued the Russian Federation, the WTO, as far as light engine cars are concerned. So I'd like to know, light commercial vehicles, and I'd like to know the results of this suit, if you know any information. Yes, that's true. We started consultations within WTO with the European Union, and the members of the Commission participate as members of the Russian delegation. So far, we have no news because we don't know how it will go on. This is the first case considered by WTO, and now our director attends the first round of consultations in WTO. We think that at the end of the consultation, we will tell you some more information. I'd like to specify certain things. What are the criteria for assessing bad faith and good faith in terms of importing goods? Because you said that certain measures could be, you mean the retroactive measures. Perhaps it concerns the companies to supply certain goods within the set time limit. The provision does not contain such notions as good or bad faith. There are specific criteria as far as large-scale imports are concerned and the damage to the manufacturers. Well, large-scale imports or massive imports involve kind of dynamics. And this is true. We have had cases like this when over several months a great amount was imported equal to the 3 preceding years. So this is a specific case, and all importers should be warned that there is an application for investigation, and the companies who cover part of the market should know it, and then they should be informed that there may be certain measures, and they take the risks themselves. So in foreign practice, this measure was not applied or has not been applied ever, and then it was even reversed, I think, but it was never used. So it depends on our wish to protect our market, to safeguard our economy, because now we have to replace imports on a large scale.
Well, now I'll be speaking about the protection of intellectual property rights within the WTO structures. This is a very relevant question because it seriously damages the development of Russian economy, and our foreign colleagues have interesting experience, and I would like to give the floor to Katerina Stephens from Bird & Bird LP. Katerina is a specialist in intellectual property, and she will discuss her extensive experience with her. Please try to, I'm asking all of you, those who ask questions, to stick to the 10 minutes limit.
Thank you. Well, thank you very much for inviting me to speak today. I'm going to speak about the importance of trademarks to consumers and trade, and the role of the WTO and TRIPS in achieving that aim. I'm going to explain in brief the issues surrounding plain packaging and the case that is now before the WTO based on Australia's Plain Packaging Act. Australia, as you may know, was the first country in the world to adopt plain packaging for cigarettes, and their laws came into force 18 months ago. But I'm going to start off by restating the economic importance of strong IP. It goes without saying that strong national intellectual property protection can incentivize individuals and businesses, small and large, in a country to invest in innovation and creativity. These investments, in turn, fuel economic growth, jobs, and continuing innovation. Trademarks are a key aspect to that IP landscape because they indicate the source and origin of goods and services, and they facilitate competition and encourage innovation in business. I'm just going to spend a few minutes now looking at the nature of a trademark. Firstly, words are not the only trademarks. Many brands consist of logos, devices, colors, shapes, and 3D marks. You only have to think of some very famous marks, for example, the Apple logo for computers, or the 3D figurine called the Spirit of Ecstasy for Rolls-Royce cars. Another famous mark is the rooftop mark. It is recognized and associated with Marlboro cigarettes because it has been consistently used by my client, Philip Morris, and continues to be used by it and its affiliates on cigarette packs. This logo is made up of both colors and shapes, and these are in trademark law called the badge of origin or source, and is in trademark law termed the essential function of a trademark. These trademarks also act as a guarantee of origin and of quality, so that when you buy a product with these marks on it, you know exactly what you are getting. A trademark grants a positive right to its owner to use to ensure that these positive functions that I have explained, that of origin and quality, can show through. That trademark has to be used. Now, some commentators say that a trademark is just a negative right. In other words, it gives a proprietor nothing more than a right to stop third parties from using a mark. But actually, a trademark has a wider penumbra of protection the more it is used. Nevertheless, and I have to admit this, the High Court in Australia, when looking at the legality of the Plain Packaging Act, found that by a majority, a trademark was a negative right. They acknowledged that the Plain Packaging Act denuded the trademark of its complete value, but nevertheless, they said that this damage was insufficient for the Plain Packaging Act to be struck down. Now, I believe that the judgment showed a misunderstanding of the financial principles behind trademark rights. A trademark right, in order to be registered, must be capable of distinguishing the goods or services of one manufacturer from the goods or services of another manufacturer, and that is enshrined in Article 15.1 of TRIPS. This definition is equivalent to the requirement that a trademark be able to perform its essential function, which I've already explained. In order to meet the essential function of distinguishing goods as well as other functions, the trademark has to be used. This principle has a practical aspect to it. In many countries, including in Russia, there's a use it or lose it rule. A trademark is subject to revocation if it is not used for a period of time. Turning now to the role of the WTO and the TRIPS agreement in protecting IP, signing up to the TRIPS agreement is a key sign of a country's commitment to protecting IP. It shows a commitment to guarantee a minimum level of protection in IP and to have any disputes about whether obligations under the agreement are being met determined as part of the WTO dispute settlement procedure. The dispute settlement procedure has been used effectively in the past to police the TRIPS agreement and ensure signatories comply with their obligations. One of the examples in relation to trademarks is the EU rules on geographical indications. In 2005, WTO held that the EU system of protection for agricultural products and foodstuffs did not guarantee to foreign nationals the same access to the system as EU nationals. Therefore, the EU had to amend its legislation. The second example, and the one on which I'm focusing today, is Australia's plain packaging rules. What is this plain packaging that I keep on going on about? Well, plain packaging amounts to an almost blanket ban on the use of trademarks on the packaging of tobacco products. Only the brand name itself can be used, but it is heavily circumscribed by rules which state it to be a uniform size, colour and position on the pack. All other logos, colours, graphic or text elements by which manufacturers usually express their brand identity are completely forbidden. In essence, plain packaging would require cigarette packs to look almost identical. In other words, the products have effectively become generic. These plain packaging rules ignore the function of trademarks and conflict with the basic principles of trademark law. Indeed, such measures effectively deprive trademark owners of the function of their trademarks because they render the marks meaningless. They also deprive trademark owners of their investment that they have made in developing those brands over the years. These plain packaging rules violate two aspects of TRIPS which I'm going to look at today. The first one is Article 15.4. This requires that trademarks shall be registered irrespective of the nature of the goods to which the trademark is applied. There is a breach here because the plain packaging rules are intended only to apply to cigarettes, that is, and other tobacco products. As explained already, registration and the right to use a trademark are inherently linked. Under Article 15.1 of TRIPS, a trademark must be capable of distinguishing to be registerable. The position is also confirmed by Article 15.3 of TRIPS, which provides that members may make registrability depend upon use. As Article 15.4 states that registration cannot be denied based on the goods in question, these two provisions would only be compatible if members were required to allow trademark proprietors to use a mark. The proposition that there is a necessary correlation between registration does not, of course, mean that there can be no restrictions on any types of goods subject to a trademark. This is dealt with specifically in Article 19, which caters for protecting and maintaining marks where the sale of the goods is unlawful. But this is very different to the position here. Here, the products are lawful, but what the government is trying to do is make the provision of trademarks on those goods unlawful. The other provision of TRIPS is Article 20. Now, this provides that a trademark shall not be unjustifiably encumbered by special requirements. Now, I can't think of a special requirement which encumbers a trademark more than preventing it from being used on packs of cigarettes. It must be, therefore, detrimental to the function of the trademark. There is one interpretation of Article 20 that says that special requirements cannot be justified under any circumstances. But even if this interpretation is incorrect, then the special requirements could be if the special requirements could be justified, it would be necessary to establish that they were reasonable, proportionate, and based on evidence. It's now necessary to pay some attention as to what exactly is the point of plain packaging. It's to stop young people from taking up smoking and reducing smoking in society as a whole, and to promote health. Unquestionably, this is a laudable aim, but how is plain packaging going to achieve it? Deprived of all branding, cigarette companies can only compete on price. Simple economic tells us that this will increase demand. At present, tobacco products are distinguished by their branding. Plain packaging so severely reduces this aspect of competition that, as I say, they can only compete on price. Now looking at the position in Australia. As I said, this was the first country to adopt plain packaging. And before the case came to the WTO, it was challenged locally by JTI, BAT, Philip Morris, and Imperial Tobacco. In August 2012, the High Court issued orders rejecting the tobacco company's case. The key question in this case was whether the Act resulted in an acquisition by the government of the tobacco company's intellectual property and goodwill. The majority, 6-1, were of the opinion that although there was very significant damage done to the trademarks, as I've already said, there was no acquisition, there was no taking by the government. The government didn't actually acquire anything, and therefore the Act was passed into effect. This is instructive when it comes to Article 20 of TRIPS, because there has to be a detriment to the origin function of the mark. And as has been proved in Australia, there was sufficient detriment for there to be a taking of the mark, although, as I said, not an acquisition by the government. This is not the end of the challenge, of course. A WTO dispute settlement body panel has been set up at the request of 5 countries, Ukraine, Honduras, the Dominican Republic, Cuba, and Indonesia, to consider the legality of the Act under TRIPS. A panel of 3 experts was appointed in early May, and they may issue their decision as early as the end of this year. The parties can, and no doubt will, appeal to a standing appellate body of experts whose final decision will be issued up to 90 days after the appeal. This means that a decision could be rendered as early as in the next 12 months. The impact of introducing plain packaging in Australia can already be seen. In 2014, the US Chamber of Commerce noted that Australia's plain packaging requirement severely limits the ability of trademark owners to exploit their rights and sends a chilling message to brand owners interested in selling in the Australian market. Trade tensions have already increased because of this law between Australia and Indonesia. Indonesia is a very big exporter of tobacco and has threatened in retaliation to Australia to ensure that all wine imported from Australia should bear plain packaging or plain labelling as a result. Query also the effectiveness of plain packaging. There have been a number of studies which show that there has been no diminution in the use of tobacco, but they have also shown that the consumption of illicit tobacco has increased to the detriment of the normal product. So I would conclude that plain packaging conflicts with basic trademark law principles by eliminating all useful meaning of trademarks on tobacco products. The WTO now has to decide whether Australia is in breach of its international obligations under TRIPS. Most countries are awaiting on this outcome before they adopt plain packaging. A number of countries are looking at it already. Ireland, however, has jumped the gun and within the last few days has published a draft plain packaging bill. My last comment would be that plain packaging has often been seen as a tobacco problem. Well, no longer. A lot of governments are now looking at plain packaging for what they perceive to be other unhealthy products. So fatty foods and alcohol are already in the sights of many governments. Plain packaging for tobacco products will merely set a precedent for how such regulation will evolve in the future. Thank you very much.
Спасибо, Катарина. Интересный доклад. Есть вопрос?
Thank you for this very interesting report. Any questions, please? Maybe I misunderstood, but if the volume of cigarette sales didn't fall, what were the losses? Actually, they gained something because they didn't have to make colorful packaging, or did the sales fall after all?
Sales overall of tobacco did not fall, but the proportion of sales relating to counterfeit products and illicit products increased. So the products that were sold by BAT, Philip Morris, the companies that were paying tax on their products fell, but the illicit market grew. So the market as a whole stayed steady.
Спасибо. Еще есть вопросы?
Any other questions? FS company. What are the trends in creating a certain supranational laws regarding import and export of goods when the demands on packaging are different? For example, the customs union, Russia, Ukraine, and Kazakhstan, we have lots of problems because apart from the supranational regulations, when there are many requirements regarding what is written on the package, there are also many local regulations. So that the packaging is about 60% of a packaging is text, and this is too long for a regular consumer just to read. We know what tendencies there are within our three countries, Russia, Belarus, and Kazakhstan. Are there any best practices that we could maybe borrow?
I can only speak from my experience in relation to being in a country which is part of the European Union. The European Union has striven for a very long time to create a level playing field in relation to goods and services, so that there can be free movement of goods and services across borders. What the Commission does is introduce laws which require minimum provisions in relation to such things, and then most countries will agree that when another country has complied with those minimum provisions, then the goods and services can move across borders. But you raise an interesting question, because the issue of plain packaging, of course, if there isn't any provision at the EU level, will automatically ensure that goods coming in from one country do not comply with the local laws of another country within the EU. So there are arguments based on the fact that they form barriers to free movement of goods across the European Union.
Спасибо. Коллеги, ну...
Thank you, colleagues. So, now we have started discussing tobacco, and the next presentation by Sergei Pipilyaev, who is the managing partner of Pipilyaev Group. He will speak on the liability for illicit trade of tobacco products in the Russian Federation. Well, he is very interested in the future of tobacco in Russia, you know, recent bans. So tobacco is just an example of what's underway, because this is perhaps a good example, because the major principle of any economic union is freedom of goods and services. And why should we set up such unions at all if there's no freedom? But the principle itself may require certain specified goods designed for free movement across borders. And the most general answer is that the principle does not imply illicit trade and does not cover it at all. So we have a unique situation in Russia because as far back as 2009, the government decided to increase excises. And starting with 2009 up to 2013, almost 5 years elapsed, excises have grown by 426%. Last year alone, the tobacco excise grew by 40%. And the excise is a markup for the price, for tobacco prices, and the incomes of population do not grow that fast. And certainly people search some cheaper products. And since there is a demand, there will be a supply, which actually is provided for by our customs union partners, Belarus and Kazakhstan. And they do it not only in the border regions alone, like Smolensk region and others, but counterfeited products go deep into the country. And, well, it's proven statistically. In Dagestan, for example, well, you know where Belarus is located and how far Dagestan is from it. So 72% is the turnover of counterfeit products in tobacco products. And counterfeit products exist across the world, but we can compare the rates of growth of increase annually. Well, on the average, it's about 5% increase annually in the world. But last year in this country, it grew, well, guess how much? 300%. It grew by 300%. So what do you mean by counterfeit products? Do you mean when they imitate well-known brands, or is it illegal production, illicit production, manufacturing? Both. So to understand what the figures actually imply, 5%, that's the pace of walking pedestrian. And imagine a sports car like Ferrari just rushing beside you 500 kilometers per hour. That's the rate. That's the pace. And as to the amounts of counterfeit tobacco products, it was 3 billion pieces last year. Can you imagine that? 3 billion pieces. So it's about 200 railway cars a month. So the whole length of such a rail carriages line will be 5 kilometers long, and Nevsky Prospect is 4 kilometers long. So imagine walking along Nevsky Prospect and coming across counterfeit cigarettes all the time. And Peter the Great, who founded the city, he actually introduced tobacco into Russia, and he would be surprised if he could see so many cigarettes or tobacco products in his native city. So perhaps you all know the Carmen novel by Prosper Mérimée, the gypsy character worked at a tobacco producing manufacturing plant with, it was like a castle, well protected with the defense barriers around the walls and so on. Spanish people actually guarded their excises then because they prevented losses of tobacco and illicit trade of those days. And let's have a look at our statistics. Last year, the share of smuggling amounted to 10%, actually, of excise revenues to the budget. So 270 billion revenues. So 20 billion was the loss of the budget. Is it much or little? Well, these are the figures provided by the finance minister. It's not mine. But it's quite larger than the maternity subsidies, it's even more than the medical costs in this country. On the other hand, the Crimean bridge to be built may cost 300 or 350 billion rubles. So the sum for excises and counterfeit tobacco products seems very small as compared to this. But on the other hand, so the overall turnover is 1 trillion rubles on the market plus 20% profit tax. So income tax. So if you consider these figures, so you can guess how much money would be needed for the bridge to be built in Crimea if we could combat counterfeit products. So the question arises, what could be done in this case? There are three options. First, we can change the excise policy altogether for the cigarettes not to be so expensive and to do away with the economic incentive to produce counterfeit tobacco. But I don't think the government will change the policy. But we should speak out on it. The other option is to harmonize the system of indirect taxes, including excises, in all the countries of customs union. Then the problem will be done away with. Not absolutely, but part of counterfeit tobacco is produced in the country. And last year, 3 large plants were detected and abolished altogether, done away with. So it was large-scale production. But this happened in one single case, and we don't know how much had been produced in Yaroslavl or Kursk or elsewhere. That's not known. And the third option is to raise liability for selling counterfeit products. This seems most dynamic and simplest instrument to be used, but regretfully it doesn't work. We seem to have certain articles in the criminal code and in the 171 article and 180 article in the criminal code, though the articles were somewhat cut a little bit and made shorter because we excluded the liability for smuggling from the criminal code altogether. And up till now, there is liability laid down in the code for manufacturing, selling, and distribution of counterfeit products, and 180 for using the illicit trademark. But not a single case was brought to court based on Article 171. You say one. Yes, there is a single case. So it's excellent because it changes the situation in principle. So as to 180, illicit use of trademarks, about 300 criminal cases were considered last year, but for 1 trillion rubles turnover, it's negligible. Why the cases are not brought to courts? There are a number of reasons which are obvious. In order to suit someone for transporting counterfeit goods, you have to prove that the purpose of transportation was selling the goods, but as lawyers we know how difficult it is to prove it. The next point is, no matter how strange it may seem, neither of the articles envisage such measure as seizure of property for these crimes. And it may be from 1 to 4,000 rubles fine instead of seizure of property. So that's nothing, actually. And which is more important is to use these measures envisaged by the articles. The amount of counterfeit products produced should exceed 1.5 million rubles worth products. So if you have cigarettes worth 1.5 billion rubles, or sorry, 1.5 million rubles, and to have an idea what it implies, so you can guess, so 55 rubles is the average price for a package of cigarettes, for a pack of cigarettes. So I could give you a practical advice. If after this forum you decide to start some lukewarm business like transportation and sale of counterfeit products, so use small trucks like, well, minibuses. It's a very cheap automobile, Russian-made, small truck. So this called Gazelle, and it can transport cigarettes worth 1,300,000 rubles. It is less than 105 million rubles laid down in the criminal code. So if you use a Gazelle truck, the criminal liability wouldn't be applied to you as the owner of the truck. And I think that these are obvious loopholes which should be filled in order to have measures envisaged to build the bridge in Crimea. And the level of, or rather the ceiling of responsibility, of liability should be certainly brought down. It should be lower than 1.5 million rubles. There are many more details concerning the corpus delicti and other things that should be considered in order to protect the Russian market and to introduce the normal liability for manufacturing counterfeit products.
I completely agree. Any questions? Thank you for this interesting presentation. I have a question. If I take you up on your suggestion and I will transport counterfeit cigarettes, why is the transportation of cigarettes within the customs union? This is free movement, right? And there doesn't seem to be any political decision to create certain fiscal policy. It's been like that in the European Union. Cigarettes or petrol, it happens all the time. And the courts were saying that there is no major problem. So you can basically transfer cigarettes or petrol from one country of the European Union or another. Thank you. This is not a question, this is a comment. Sergey, you're an expert in tax law. What is your forecast regarding the prospects of budget loss due to Belarus and Kazakhstan counterfeit products in percentage and so on? You're right. There are lots and lots of trucks with Belarus cigarettes on the border. Can you give us figures? What are we losing in the future of the Russian budget? Well, excise duty, the loss of excise duty in 2013 is almost 20 billion rubles. This year, how much faster counterfeit will be going? If the pace will remain the same, we'll have not 3 billion, but rather 9 billion. People won't smoke more, even though cheap products lead to increase of consumption, but the major effect is pushing out domestic producers from the market. So we're losing in taxes from domestic producers and domestic manufacturers who won't be paying taxes because they won't be able to produce and manufacture as much. You outlined 3 options, but marking RFID mark, which will make it difficult to sell it in retail. That's probably more difficult. You could do it on the black market, but not through legal channels. Thank you. And this is a very interesting discussion. Lively, too. Thomas Snelling will, from Freshers House, Derringer, and Thomas Snelling will speak about anti-illicit trade in the UK. Please.
I have a slightly difficult job because I have a slightly difficult job because I'm one of the last speakers of the day, and the room currently is as hot as it will be tonight when England play Uruguay in Brazil. So I'll try and be quick. I'm going to build on some of the things that Catherine and Sergey have been speaking about, but I'd like to talk about them from a UK perspective, where some of the challenges with illicit trade are actually less about counterfeit, but about the movement of legitimate product from other EU member states into the UK. And the UK has developed a legislative regime to try and deal with that issue, and that's creating opportunities and challenges. So the European Commission released a report yesterday. Around 816 million cigarettes and about 240,000 litres of alcohol were seized by the European authorities last year, which were said to be illicit. And illicit in this context isn't just about counterfeit product. It's product going from one market to another market where tax isn't paid in the intended market. There's also a whole series of cases whereby people are now very sophisticated in terms of the use of illicit trade. Recently, a drone was captured by the Russian authorities, which was flying over the border between Lithuania and Russia, and it had special magnets along its wings so that the cigarettes could hold up over the border and then instantaneously would drop as soon as it had flown over. There's a degree of creativism going on here which should be borne in mind. The problem in the United Kingdom is the concern that illicit trade products, both alcohol and tobacco, undermines public health policy. We have actually a good regime in stopping those products getting to young people, but that's being severely undermined by making illicit trade easier to sell. The illicit traders in the United Kingdom aren't concerned about who they sell to, and the 16-year-old who can't lawfully buy alcohol or tobacco will be able to get access to them unlawfully. We have the challenge that you were talking of in terms of the customs union, that our excise rates on tobacco are much, much higher than any other EU member state. Even a value cigarette product in the UK or cheap wine is considerably more expensive than elsewhere in the EU. And this makes the UK something of a haven for those who are trading in illicit goods. You were talking about three possible solutions from a Russian perspective. Interestingly, the United Kingdom has just said it's going to change its excise regime for tobacco to try and tackle some of these issues as well. So there might be some mutual learnings. The piece of legislation I wanted to talk about quickly is the 2006 supply chain law. This is very special, and I don't think there's another example of it in the EU, where special obligations are placed on the manufacturers of tobacco products to be able to confirm that they are not facilitating smuggling. This is a concern that a lawful manufacturer is oversupplying a neighbouring market and the products coming back to the UK. And this legislation requires manufacturers in the UK to be able to confirm to the government, and the part of the government is Her Majesty's Revenue and Customs, HMRC, that they can explain their supply chain, that they fully audited their supply chain, and they have a written policy which will be able to evidence the fact that they are not oversupplying neighbouring markets. HMRC can demand to see a copy of that written policy and has been increasingly testing those policies to see whether they are sufficiently strong. Because recently it's been suggested that the UK Exchequer is losing out per annum $3 billion on tobacco and another $2 billion on alcohol. It's a significant sum. HMRC has the ability to specify brands, countries and places. So if it has specific concerns about a type of tobacco product or a country where a manufacturer is selling that product to, and for example Belgium is a very low tax jurisdiction in the EU, HMRC can say to the manufacturer, we are making a specification, and this places enhanced obligations on the manufacturer to be able to prove exactly who they're applying this product to and who their customer is and who their customer is, and ultimately the end user. HMRC can issue a penalty notice of up to $8 billion for non-compliance. And significantly, the first time a manufacturer can test the decision-making by HMRC is when they've received that penalty notice. So unless you go to court and obtain judicial review, there's no system in place whereby you can question the decision-making by HMRC. Alcohol doesn't yet have the same regime, but we're moving towards it in the UK. So in 2012, the UK government said it was going to apply to beer manufacturers the same supply chain obligations currently on cigarette manufacturers. The beer manufacturers were somewhat reluctant to agree to this. They said it would raise competition law issues and complained about the high implementation costs. As a result, the government has reconsidered its position, and it's going to be introducing a law later this year which will include a requirement of statutory due diligence. So in the alcohol context, you'll have to carry out reasonable checks to establish the credibility and legitimacy of new customers, suppliers and supplies. You'll have to prove to HMRC that you have a legitimate, justifiable market for the goods you are supplying. And this is a significant change, I think, in terms of control of alcohol within the UK, and it's something which might be looked at elsewhere in the EU. So you might ask me the question, is it working in the UK? Is this something other countries should consider? Well, the UK Parliament said on Saturday, through one of its committees, we're still worried that not enough is being done by the government and its appropriate agencies to combat the problem of smuggling at source. While there have been some high-profile successes, over the last 3 years, the numbers of prosecutions and convictions for organised crime cases have fallen. We do not believe that these numbers are decreasing due to the reduction in this type of crime, and we are deeply concerned that these figures may indicate a reduction in enforcement action. The British have a reputation for sometimes being overly polite, and it's not always clear exactly what they mean. That is Parliament saying, we are concerned that HMRC is not doing enough to tackle this trade and that the criminal gangs are not being prosecuted more, there are actually less prosecutions. So the supply chain legislation is there, but the concern from Parliament is that HMRC is not doing enough off the back of it. On the ground, HMRC depends upon assistance from major manufacturers of alcohol and tobacco, including my client JTI. And the reason why it's been mentioned earlier is the legitimate manufacturer is often best placed to identify whether a product is licit or illicit. This information then gets given to UK Border Force, who act on behalf of HMRC in seizing and destroying these seized products. Manufacturers are also encouraged to assist in the training of retailers and law enforcement officers to make sure that there's additional information to help identify these illicit trade products. But the legislation also creates legal problems, and today is about comparative law issues, so it's worth maybe mentioning them briefly if I may. It does not impose a duty to investigate all manufacturers equally. And as I've mentioned earlier, it doesn't allow the manufacturer to question the decision-making until they've received a penalty notice. And at that point, it's frankly too late because of the reputational harm there will be of receiving a penalty notice, which will be accompanied in the United Kingdom by considerable press interest. Are the courts an answer? HMRC is part of the UK government. That means its decision-making is open to scrutiny by the English courts, and we call this process judicial review. So there's a formal mechanism, at least in theory, for testing decision-making. But there are problems with this. It's hugely expensive to do a judicial review in the UK. And even if you're successful, the decision of the court does not replace the decision of the decision-maker. So the courts have the power to quash decisions, but if they have a different view on the merits, they won't substitute that decision. So what lessons can be learned from the UK experience? In practice, the supply chain legislation has created significant uncertainty for legitimate manufacturers, and the reality, according to Parliament, is it's failed to prevent the free movement of illicit trade products. There's no simple answer to this problem, though, Moderator. Undoubtedly, with these issues, you're going to need to have extensive cooperation between legitimate manufacturers, enforcement agencies, and senior members of the government. And cross-border cooperation is critical for us in the European Union context. And the manufacturers in the EU have signed a cooperation agreement, and this commits them to supporting the EU investigating illicit trade issues. And it gives a special role to the European Anti-Fraud Office in relation to supply chain breaches. Finally, a warning. Beware the law of unintended consequences. An issue in the new WTO dispute about tobacco, which Catherine was talking about, is the risk that well-intentioned national measures may unintentionally make illicit trade worse. And a leading expert in this field has said recently, policymakers should be exceptionally careful to ensure that regulations do not inadvertently undermine anti-illicit trade programs and initiatives. Thank you.
Спасибо, Том. Мне кажется, очень интересный опыт.
Thank you. Thank you for this very interesting description of a very interesting experience. Sambev Brewery. This is probably not a question to Thomas, but also for Mr. Pepelaev. We understand that the situation that the tobacco industry has found itself in is a result of certain actions, wrong actions of the industry. We now see problems with alcohol and with beer. And in our industry, there is no counterfeit products. They're making illicit beer is basically brewing it anew, which is a very difficult thing. But we do understand that we are linked to alcohol products, so any limitations imposed on alcohol products will be reflected on us. What does the alcohol manufacturers have to do to avoid the mistakes already made by the tobacco industry?
I think it's a very good question. And undoubtedly, you're right to draw a distinction between the manufacturer of beer and the manufacturer, say, of spirits or wine, because in the UK there is a significant problem with counterfeit wine coming into the UK. There's also a significant problem with untaxed vodka coming from the east towards the west. I won't be more specific than that. The beer manufacturer, I think, needs to learn the lessons from big tobacco of being aware that engaging in the debate is more likely to lead to a sensible outcome than trying to stand away from the debate. The context of tobacco and beer are different, but I suggest maybe one thing the beer manufacturer should look at is how trends in tobacco have carried across to other consumer products over time. And I'm not suggesting that immediately after plain packaging for tobacco, you will see it on alcohol. But if you own Veuve Clicquot, with its distinctive orange label and the picture of the widow Clicquot on top of it, any suggestion that there's going to be standardized packaging is going to be a deep concern to you. So I know that the French champagne industry in particular are looking at this nervously.
Спасибо. Есть еще вопросы?
Thank you. Any more questions? Dear colleagues, finally, another topic we would like to touch upon today at this panel, not quite round table, thanks to the problems of regionalism. This is becoming very important. And this is the problem of conflict that are typical of many regional trade agreements. We don't see much of that yet, but since our future relations with WTO members and us being a new WTO member, we decided that this topic might be quite interesting. So I would like to give the floor to Vladimir Krochmal, the Director of Legal Department of CIS committee, and he will speak on the problems within the CIS. Thank you very much for this opportunity to speak about jurisdiction conflicts in settling trade disputes within CIS. I'd only take up a little of your attention. The report was prepared by the Eurasian Institute of International Law, which is a very new institution oriented on research and providing expert opinion in the field of international law. The center, its attention is focused on Eurasian integration, the integration on the post-Soviet, in the post-Soviet area. In the year 2000, I listened to the well-known talk by the President of the United Nations International Court, Gilbert Guillon, who said that interjurisdiction conflict was becoming important in international disputes, and this problem is becoming more and more relevant and more central to many discussions. One of the prevalent views here is that jurisdiction conflicts are not special. This is a general byproduct of globalization. Jurisdiction conflicts are situations when two or more international forums in parallel or consecutively make decisions that are in conflict. Another well-known rubric in international jurisprudence are regional trade agreements, and there are no exception to the rule. Most regional trade agreements are rife with this sort of conflict because creating preferential free trade zones, customs unions are subservient to GATT conditions, GATT conditions, Article 64, 194, and so on. And thanks to that, very understandably, most disputes on regional trade agreements are also discussions and disputes regarding WTO legislation. There are only a few examples when a jurisdiction conflict could be an obstacle to for a court or quasi-court structure to exercise its jurisdiction and its legality. In certain circumstances, jurisdiction conflict leads to the so-called practice of forum shopping, when the parties selectively hand over the dispute to this or that institution, which, according to its expectations, will meet its demands, will create the desired precedent, or somehow benefit this specific party. And I will try to look at these aspects in light of the recently concluded free zone agreement of CIS. 7 states are parties to this agreement: Armenia, Belarus, Kazakhstan, Kyrgyzstan, Moldova, Russia, and Ukraine. Tajikistan didn't ratify this agreement, and Uzbekistan is not a member, a signatory to this treaty, but uses it as on the basis of a special protocol.
So you can see on the screen the list of provisions of the treaty which make up the legal framework for dispute settlement mechanism. Article 19 of the treaty is first. It establishes a special body of CIS countries, which is called Expert Commission, which has its own competence, and also it can distribute its competence among other alternative forms. That is, bodies of dispute settlement under WTO, third-party tribunals or appeal bodies, and also the economic or commercial court of CIS countries. We believe that such a document, that is agreement on dispute settlement like WTO has, is entitled to be included in the list as the treaty proper on free trade should get new and effective interpretation, and the provisions of the treaties should be considered as complementary. The next table on the slide well, something is wrong technically. That's it. So the table number 2 shows judicial and quasi-judicial bodies which are involved in dispute resolution, like the Expert Commission, also WTO, dispute settlement mechanism, and the CIS countries economic court. There's no ad hoc jurisdiction to be considered. We prefer to have permanent jurisdictions under question. So we also have documents which identify types of documents, types of disputes, and that could be settled. And we see that the discrepancies are rather large. And outside specific cases, we cannot assess the advantages or disadvantages of a party which can choose a jurisdiction preferable. Comparing it with the general plan, we can identify the following things. The free trade zone agreement does not cover the disputes which do not involve direct violation of commitments or obligations which are not covered by certain policies and political measures of the parties to the treaty. And thus it coincides with Article 23 of GATT 94.1a. And the next point of the article of GATT agreement allows consideration of disputes by WTO which do not imply direct violation of commitments, but they result in doing away with the profits, with the expected profit, and these are the so-called non-violation and situation complaints. And certainly there are some problems with the treaty and some gray zones, perhaps. The Commission of Experts of CIS countries may or may not accept the last category of disputes, and we will find the solution to it in our experience to come. I will save time and draw your attention to the following. We have our specific jurisdictions defined for each of the bodies. And here is a list of articles from the Treaty on the Free Trade Zones of Serious Countries, which refer to GATT provisions. And as far as such references are concerned, we have Article 19, which provides for such a possibility to go to WTO for dispute resolution, and such references in certain cases are limited by 3 articles, Article 6.1, Article 10.2 and 3, and these are just definitions which have been borrowed, like state procurement. And the question arises whether such a reference will do to consider the regulation of this part sufficient. Perhaps no. I believe that the issue should be considered in the would-be CS jurisprudence. And as far as WTO jurisdiction is concerned, we can consider it in a broader way. That is, any dispute emerging from violating the provisions may be submitted to WTO based on the rules and provisions of the World Trade Organization proper, because they have the principle of judicial autonomy, and they are very consistent in promoting it. WTO will accept any dispute which comes under the provisions of WTO agreements included in the Agreement on Dispute Settlement Mechanism. Any party to the agreement going to WTO can fill in a standard form for third-party tribunals' powers, which will consider the dispute and indicating the agreement which is referred to and the facts which are covered by the agreement. They can also be violations under the Free Trade Zone Agreement or treaty. As to jurisdiction of individuals, the broadest, or rather jurisdiction of the bodies, the broadest is provided for the Commission of Experts, and 5 WTO members can apply WTO jurisdiction, and 5 countries which have recognized the jurisdiction can also go to WTO for dispute resolution. And since it is not optional but mandatory, it also indicates which specifically of the fora will be applied to in case there is a complaint as to the conduct of a party. For WCS countries, the potential of this is very powerful, because so far we have no commitments on coordination, and disputes will emerge in the framework of WTO and the Experts Commission of the CS countries. So disputes under the Economic Court and the Commission of Experts are less probable because the Economic Court is rather polite judicially. And I think that the major area for jurisdictional conflicts will be the Commission of Experts and WTO. I mentioned the principle of autonomy of jurisdictions, and thanks to that, it is obvious that it will provide the disputing parties with very vast powers, and they cannot be restricted based on the fact that a similar dispute was considered in a different jurisdiction. There are a number of exemplary cases in WTO jurisdiction, like Mexico, Texas, and Salt Drinks case. And since then, and giving up jurisdiction in similar circumstances deprives WTO members of the right to go to WTO to protect its right, which has been violated, thus entailing violation of the provisions for a dispute settlement mechanism. And even though the dispute may be initiated elsewhere and not in WTO, other procedural parties could repeat the same proceedings and achieve the same outcome.
WTO, статья 19.
Unlike other documents, Article 19 on free trade zone and the Economic Court provision do not declare the autonomy of their jurisdictions, and they can be provided to a party for selection. Considering all potential conflicts which may emerge, well, I think that we don't have time to consider all your slides. Perhaps you would rather reduce their numbers somewhat. Well, in a more systemic approach, we can see that under any procedural conflicts, the parties will violate their own commitments as far as WTO law is concerned. That is, their commitments to settle disputes. And Article 19, which I mentioned more than once, will be not applicable in such cases. A general opinion is that such conflicts cannot be settled based on general principles of international private law. And effective means of settling judicial conflicts have contractual nature. To put it in a nutshell, the proposals designed to reinforce Article 19 in a way will be borrowed from international practice or case law. And the only common forum for all parties to the dispute out of 3 alternative jurisdictions will be the Commission of Experts. Thus, we can simplify the rules, retaining freedom of choice as far as jurisdictions of parties are concerned, and we could also establish the following rule. If a party is going to initiate a dispute settlement in WTO, it should inform the other contracting disputing other parties to the dispute, and if there's no agreement among them, then such an agreement should be provided to the Commission of Experts and considered within its jurisdiction. The same goes for a third party participating in a jurisdiction of conflict, if the party has a material interest in the case. In conclusion, I'd like to stress that it is obvious that free trade zone agreement or the would-be agreement on the free trade of services agreement should have a single mechanism for dispute settlement. And this may be a reason for reconsidering Article 19. And in conclusion, I'd like to thank our interpreters who have to cope with our very difficult presentations. Thank you.
Справились с такой сложной задачей, с такими сложными определениями, текстами, дефинициями, предложениями. Коллеги, вопросы к Владимиру есть? Или доклад был исчерпывающий, удовлетворил все интересы? Все. Тогда спасибо всем большое за участие. До новых встреч.